rise. Court is open and back in session. Good afternoon, Your Honor.
Good afternoon. Good afternoon again, folks.
You may be seated.
Mr. Reyes is on the stand, and I'll turn it over to you, Attorney Fahey.
Thank you. Mr. Reyes, let's start with the animosity between you and Sergeant Fahey. You, back in approximately 2021, went to the state police headquarters to try to make a complaint about something that maybe happened at the airport, something along those lines. Is that correct?
Yes, in 2021, I was unlawfully detained by...
I'm not asking that, sir. I'm asking, did you go and make your opinion of what you were or weren't doesn't matter. What I'm asking you is, did you go to state police headquarters, yes or no, to make a complaint about something that happened at the airport?
My answer is that
yes, right?
I went to
yes.
My answer
That's your answer,
my
sir.
Answer is...
I'd ask the court to direct them to answer the question as asked.
I'm answering the question.
All right. And so I think the disconnect is that if you're asked a question that requires a discrete answer, I'd ask that you answer it discreetly. You'll have an opportunity, to the extent that it's not objectionable, to offer further explanation in redirect. But to the extent that you can discreetly answer the question being asked of you, especially if it is a yes or no, I'd ask that you do that, sir.
Well, I don't think it's a yes or no, but I understand, Judge. Judge, may I grab a pen from the table?
You may.
I appreciate that, Judge. Thank you.
Yes or no, you went to state police headquarters.
Why are you so
complain?
aggressive?
Mr. Reyes, why don't you just answer my questions and stop engaging in commentary with me?
But can you please be polite?
I am polite, sir. Why don't you answer my question? I asked a very polite question, you just continue to ignore it. Yes or no, you went to state police headquarters to make a complaint about something that happened to you at Bradley.
Yes.
And you attempted to try to film in the lobby, correct?
What lobby?
Of the state police headquarters.
While I was making the complaint, yes.
Yes. Because it would be normal to film in a restricted area while you're making a complaint about something that happened at a totally different location, correct, sir?
A public lobby is not a restricted area.
Is it a locked door to get in, sir? Is there a metal detector to get in, sir?
That doesn't make it restricted.
Well, that's your opinion, sir.
Any member of the public can walk into that lobby.
And not videotape. Did you try to enter post at some time to videotape despite that being locked?
Can you repeat the question?
Did you try to enter post at some point in Meriden, which is a police training facility, to try to videotape?
I was
Did you attempt?
I was
Yes.
led into that facility, correct.
Okay, but
And I
did
was
you try to
reported.
enter, in fact, on your video, you're rattling a locked door, correct? And then
Yeah.
ultimately you're let in.
Correct.
Let's go back to the interaction. So when you go to the state police, the person who confronts you and has a physical altercation with you is Sergeant Fahey, correct?
What do you mean by physical altercation?
Did you get involved in a shoving match of some sort, or did he shove you, or however you want to characterize it? Was there physical contact with you as you asked during your, or talked about during your direct, or asked
Yes.
Attorney Daigle?
Yes.
Yes.
Sergeant Brian Fahey made violent
My
physical
question is,
contact.
did you had contact with you, correct?
Yes, he made
Right.
contact with me violently.
And at some point, you claim he broke your phone during the altercation too? Yes or
Yes.
no? And as a result of that altercation, at some point you file a civil lawsuit?
Yes.
And you went back to headquarters another time, and at that point, during that video, you indicated, and maybe we'll run into Sergeant Fahey again? Do you recall that?
He does work there, so yes. I went there to file a FOIL request.
Okay. But you made that comment on your video, correct?
He did work there.
That's not my question. Again, please answer my question and I'll be
I
polite.
just did, yes.
Was the civil lawsuit pending before or after that second encounter?
It was not pending at that time.
Okay. You filed that afterwards?
Yeah, I'm holding to hold him accountable.
That's not my question, sir. Could you please answer my question? We'll get through this a lot quicker.
Ma'am.
Did you file it afterwards? Yes or no?
Yes, to hold him accountable.
You can keep mumbling under your breath as much as you want, sir.
I'm not
You
saying-
are.
All right.
Please answer my question
That
as
is
the
my
judge
answer. You're
instructed
asking
you.
me a question, I'm answering.
No,
you.
you're not. You're commenting afterwards. Feel free to do that during argument. So at the time of July 11, 2025, you had a civil lawsuit pending against Brian Fahey, and you had two encounters with him that you videotaped at State Police Headquarters, correct?
I had a pending civil rights lawsuit for violation of rights, that's correct. And I did not have a physical encounter with him.
Did you have an encounter with him that was argumentative the second time?
I didn't argue with him.
That's not my question. Was there words between you? What was the point in videotaping and hoping you saw Brian Fahey that day?
Well, you're characterizing it as hoping. No, I didn't characterize it as hoping to see Brian Fahey. That's your testimony here today.
On July 11th, 2025, had you had two encounters with Sergeant Fahey at State Police Headquarters, and did you have a civil lawsuit pending against him?
Yes.
And you drove, as you term it, a journalist, you drove an LED truck showing that encounter to Brian Fahey's house on July 11th of 2025, correct?
That is correct. I would just like to clarify.
No, there's no question pending, sir.
I want to clarify my previous answer. I didn't drive it up his driveway to his house.
I didn't ask you that. I said to
I
his
drove it
house.
to the public street in front of his house. Correct.
Did you do some research on how to get to his house?
What do you mean?
Well, you had to figure out his address at some point, right?
That's public record.
Yeah, how'd you do that?
I went to the town of Groton.
You made a separate trip to the town of Groton to find out where he lived? Or
That's
did you do
right.
it that day?
I don't recall.
Okay. Well, do you recall driving to Mystic once or twice?
I didn't have the billboard truck with me, so I must have been a separate day.
Do any Google searches of his property?
Not that I recall.
In fact, about a week after the July 11th, 2025 incident, Brian Fahey was scheduled to be deposed by you in your civil lawsuit, yes or no?
I don't know the exact date of when he was supposed to be deposed.
Was it a short time after the July 11th date?
It was after that date. I don't know when it was.
Was it a year after that, or was it within weeks after that?
I don't know.
What, has it happened, or was it scheduled to happen before now?
Yes.
So we're about a year and a month out from that incident, correct?
Correct.
It was much closer to the time that he was scheduled to be deposed, correct?
I don't recall.
Okay. But he was scheduled to be deposed before you went up on his property. Scheduled to be deposed.
Possibly.
Do you recall making comments to Sergeant D'Angelo that day that you didn't like Brian Fahey and he didn't like you?
I don't recall.
Does it sound like something you might have said?
It's possible. I don't recall everything I said. that
Did you
day.
like Brian Fahey on July 11th of 2025?
I don't like Brian. I didn't like on July 11, 2025. I didn't like Brian Fahey's actions as a law enforcement officer.
That's what that was about? The whole thing was about his actions as a law enforcement officer.
Yeah, and the lack of accountability he gets when he engages in criminal conduct.
So you keep referring to criminal conduct. The reality is, with respect to the overtime, did you do any research into union contracts in the state of Connecticut as it relates to police officers and their departments on how they accrue overtime? Yes or no?
I never received anything when I put in my
Did you?
request. Yes.
You looked into union contracts.
I looked into the payroll.
No, that's not my question. You specifically looked into union contracts as to how officers may accrue overtime as it relates to their pension.
Not yet.
No, not yet.
Thanks for the tip.
No, you're welcome. Because the reality is, sir, you're not really a journalist, right? Journalists vet things.
Well,
You,
he's
let me,
testifying as to what
I'm asking leading questions. Journalists vet things, don't they?
And I did.
Okay, the allegations you hurl out in your videos Nice videos like, TSA's doing a really good job. That wouldn't get a lot of clicks because that's how you get paid, right? You get paid by clicks, among other things.
Just like journalists.
Journalists on CBS are getting paid by clicks?
Of course they are. Ad revenue, of course, counselor.
Well, that'd be CBS, that's not the journalist. But the reality, sir, is that, you keep laughing, and I know it's funny to you, but
don't
the
know what you're
reality
talking
is,
about.
your videos,
No idea what you're talking about.
have you started GoFundMe pages before you had encounters with people to cover legal expenses?
Before I counted
Yes,
people?
before you've ever encountered
Not that I
people.
recall.
Have you started GoFundMe pages afterwards?
Yeah, lawyers are expensive.
And here you are representing yourself.
Consultations are expensive.
You saw that first sign going up the driveway, right? You said that as much. You saw
Oh, I saw the sign, I
Yep.
clearly saw, I opened up my eyes and I saw the sign, yes, sir.
Great. And so you did no further looking as you talked about how important it is to look for trespassing signs. You did no other looking for any signs that was 5 feet in front of that sign, right?
I'm not gonna dig through the bushes.
We want to do a thorough investigation whether you should be on someone's property, right? Now, you say you're always respectful in your videos, right?
I try to be always respectful.
Really? So, last night's video, when you said that the Fahey's daughter, you heard it's really easy to get with her. That's being respectful or has anything to do with this
Objection,
case?
what does that have to do with anything?
Did you say it?
What objection?
Did you say it?
Can you let him rule on the objection, or you're gonna be aggressive? You're better than this, counselor, come on.
The objection is overruled, and you can answer, sir.
Did you say it?
I was reading a comment.
Did
from
you
one-
say it?
I was reading a comment from one of the viewers.
Quite a journalist.
Opinion journalism.
How many lawsuits have you filed, sir, out of these cases where you go in for all your videos? How many lawsuits have you filed?
I couldn't tell you.
Lots, huh?
Probably on one hand I can count.
Okay. And you threatened to file another one last night in that video when you were being respectful?
No, I didn't threaten to
Yes.
file one.
Yes, you did.
No,
You
I
said-
said I was going to file one.
Okay. And when you were found not guilty, you were going to file a lawsuit, and you were going to own that house, and you were going to go back to that circle the minute the protective order was over, correct?
To protest, this is my First Amendment right, correct? Not the property, because I now know my license and privilege has been revoked.
You are a convicted felon. You have a
Objection.
conviction for attempted robbery in the first degree out of the state of
Objection,
New
Your
York.
Honor.
Goes to credibility.
A 15-year-old,
You were released in 2016, sir.
a 15-year-old, and I was convicted for more than 15 years ago. When I made
Was it
it
2016?
I wasn't convicted of any lies, I wasn't convicted of any fraud.
Robbery is inherently goes to credibility in the state
It
of
was
Connecticut.
15 years ago, Judge.
Were you convicted of attempted robbery in the state of New York?
That's correct.
And you've also been arrested for criminal trespass in the state of New York?
When?
Multiple times probably, but at least in sorry, it's long. 2023.
Was I arrested or
Yes,
convicted?
arrested.
I was arrested,
Yeah.
was not convicted.
You were arrested though, goes to knowledge, Judge. Were you convicted of simple trespass in Danbury within the last couple of years, Connecticut?
Violation?
Were you convicted of simple trespass?
Yes.
Have you been arrested for criminal trespass charges in addition to the two I've noted? Or other simple trespass?
Well, yeah, law enforcement officers violate my rights
That's
all
not
the
my
time.
question. Were you arrested for it?
Yes,
Yes
they
or no?
violate my rights all the time.
That's not my question, sir. Yes or no? Have you been arrested other
People
times?
like you hate it when you get challenged. You hate it.
Sir, Were you arrested more times than that for simple trespass or criminal trespass?
Yes.
How many would you estimate?
Maybe once, one more time, I'm not sure.
What did you mouth Sergeant Fahey on the stand yesterday?
I didn't know anything since I could pay that I recall.
That you recall? I mean, it was yesterday. Did you or didn't you?
Did you see me mouth him?
I'm just asking you
Nothing,
questions,
sir.
sir.
I don't recall mouthing him.
Would it be fair to say you have absolute disdain for Sergeant Fahey?
No, I don't hate anyone. I hate the conduct of certain people.
Have you launched allegations on your video after the encounters with Sergeant Fahey that you claim people have told you about, but you don't know for sure? Like that he was with hookers or that he sold drugs when he was at New London Police Department out of the evidence room. Things along those lines? Have you said that?
Yeah, people give me information and I share that information. That's what a journalist does.
And you vetted it beforehand?
That's why I said they were allegations, sir. I didn't say, I specifically say that I didn't confirm them to be true. They're allegations. Everyone's innocent until proven guilty in court of law.
Well, it's not that. I mean, you haven't come up with one shred of proof beyond what you said on those videos, correct? Did you go research any of that?
Research which one?
Any of them?
So the only proof I need is the proof that Sergeant Fahey spit in my face.
No, that's
and you
not,
covered
sir.
for
No,
him.
sir.
You
That's not
covered
the
for
question,
him. He
sir.
menaced me with a firearm
See?
and you covered for
So
him.
we're gonna have the next question.
You done now?
Are you done defending criminals?
I represent the state of Connecticut, sir.
Well, there you go.
That's my job. You have overwhelming animosity for Mr. Fahey and what you claim his actions are.
No. And is it for his actions? I don't have animosity for his actions. I don't think you can have animosity for actions. I disdain
Yeah.
the actions that he has engaged in multiple times unprovoked against me. Yes, those actions are reprehensible and he should be held accountable for them, but he's a cop, so he's not held accountable for them. And the world sees it. The world sees it.
I have no further questions, sir.
Judge, I would like to address the felony conviction that State's Attorney Fahey brought up. When I was 20 years old, I made a bad decision. And the difference between me and Brian Fahey and every other cop that engaged in
Objection, relevance,
misconduct,
Judge.
I'll move on. I made a bad decision. I took accountability for it. I paid my debt to society, and since that day, 15 years ago, I have not been convicted of any crimes. I have built a business. I have a wife. I have 2 children. I've been invited to speak as a convicted felon at police departments,
Objection.
ride-alongs,
This whole line, Judge, it's simply a character.
and I'm rebutting my character so you can understand
So
who I am.
the court will allow what you've said already, but the court's not gonna permit us to go too far down this road.
Understood, Judge. Being a convicted felon, I have a family who loves me, I have friends who love me, who trust me, haven't been convicted of any crime since, and I've since worked with police departments across this country. I invite police departments onto my channel to speak and bridge the gap between law enforcement and the public. I don't just put out negative content. It's just unfortunate that when I do put out negative content, it's because of the actions of the other officers involved on the scene. I have no animosity for Mr. Fahey. I did never spit in his face. I never pulled a gun on him.
Please not allowed as a convicted felon.
Oh, so funny. You are a state's attorney acting like a child.
It's not. It's just
You're acting like a
statements.
child. You're not supposed to be speaking right now, are you? Thanks. Appreciate it. Judge, The state's attorney, John Fahey, I don't even know if he has a relation to Mr. Fahey. Who knows? We don't have a 23andMe DNA test. But he's trying to disparage my character for some
Well,
a
Judge,
bad
this is
decision.
beyond,
I
this
made.
is the argument later if he wishes to say that.
I agree, this is our argument, sir.
I never hoped for Brian Fahey to come out and see him that day. I want to hold, every action I took was to bring awareness, including my beautiful 14-foot LED billboard truck, showing what Brian Fahey's misconduct was, to bring awareness to the residents, to the public at large. He's not special. He's not the only person I've ever protested peacefully with a billboard truck. I've never engaged in violence against a public official. I have never even, that I can recall, cursed at a public official. I try and remain peaceful during these interactions. And the fact that Brian Fahey couldn't control himself should not be a negative, should not paint a negative light on me. I did go to the police headquarters 2 times for legitimate business. One, as State's Attorney Fahey said, to file a complaint. 2, to do an open records request, which I never got. Yes, I went to film inside of the precinct. He's talking about me filming inside of the police lobby. He asked me about that. I'm explaining that to the court. Yes, I attempted to film inside of the Connecticut police station lobby. And when I was told that I couldn't, and I couldn't enter while recording, I said, fine, let's do the complaint outside. And that's when, unfortunately, I first became aware of former Sergeant Brian Fahey. We did the complaint outside. I was very cordial to him during our conversation. He was the aggressor. And when I went back the second time, was not looking for Sergeant Fahey. I was speaking to another officer, another state trooper. Sergeant Fahey appeared and waved at me. He waved at me, knowing we had that other interaction. He came out and waved at me, Judge. Waved. And I was permitted to record in the lobby that day. And Mr. Fahey stood there in the lobby. He didn't go to his office, he didn't go to the pistol permit section, he stood there in the lobby. Because Sergeant Fahey's not scared of me, we've said that many times, regardless of a felony conviction 15 years ago. I went to the house, to the residents, to conduct what I believe to be a knock and talk. I did not see a sign that said no trespassing or anything to me that would indicate I could not enter the property. I fully believed on that day, as I fully believe on today, that I had an implied license or privilege to knock and talk. And I want to clarify something for the record. Yesterday I said I wasn't on trial. And obviously I am. But that's because I shouldn't be on trial. Brian Fahey should be on trial, but he's not, because he's above the law. I'm innocent. I hope this court finds me innocent. I have nothing further to say.
I have a couple more questions. So the fact that he waved at you in state police headquarters set you off. I mean, you were mad about that. You just said that, right? You were upset that he was standing there staring at you and waved at you.
I had great emotional control.
That's-
No,
but-
I wasn't upset. I was
the-
indicating to the court that you are indicating that I went there searching for him, but yet he came out and found
Oh,
me.
no, I wasn't saying that. You did say before you went in, maybe we'll run into Sergeant Fahey, correct?
He works there.
I know, but that you said it before you ever encountered him, right?
Right.
Okay. And so you just made a big point of the fact that him waving at you and he stood there while you were conducting legitimate business. And I'm not questioning your legitimate business at all. I'm saying that was upsetting to you somehow, that you still remember that he waved at you and stood in his doorway.
No, that's
right?
not my testimony. That's what my testimony is that he waved at me. Obviously, if you don't want to be around somebody, you don't come out and wave at them. You stay away from them.
And so you went to his house thinking you were somehow invited there or welcomed there by Brian Fahey, or had some license or privilege to be there?
I think I have a license or privilege to knock on anyone's door.
I understand what you think. That may or may not be the law. That'll be up to the court. But I'm saying you knew this was going on between you and Brian Fahey, and you thought it would be a good idea to go to his house in the middle of a civil lawsuit and approach his door. Is that what you're saying?
I exercise my rights peacefully.
Okay. Well, if you have a right to. The other thing is, too, you indicated you never expected him to even come to the door and encounter you. Yet you went up his driveway. You indicated in your own direct testimony that you somehow knew he was home. I don't know if you waited there or
That's
whatever.
not my
but
testimony.
You said you knew he was home in the middle of the afternoon.
I knew he was home when he came out. I didn't know he was home. How could I see? I couldn't see if he, how would I know if he's home or not? I did not testify to that, no.
Did you not say on the video that you knew he was home because it was the middle of the afternoon and now you're checking because it's 3:45 and how could you be making all this overtime being home?
Sir, you're misunderstanding me. I said that once I went there to determine whether he's going to be working at 3:30 in the afternoon on a work day. I didn't determine that until Brian Fahey answered the door.
Okay. But you didn't say to him then, what are you doing home at 3:30, right? You didn't even, you just
He
said.
pulled a gun on me.
Not then, sir. Not then.
I couldn't even get the question out. He told me to
Not
leave and I
then,
left.
sir. He went back in the house before that whole
He had to
time.
get his gun to shoot me. He said he was going to shoot me.
You're still here and he didn't shoot you, right, sir?
Thank God. Thank God for my
I agree with
cameraman.
that.
Thank God.
I agree with that. But he never even raised that gun at you, right?
He
had
said
his
at
gun ready.
911 he was going to shoot me.
But he didn't, right?
Thank God.
I agree. My point is, you said you didn't even think you were going to encounter him that day, or you didn't think he was going to come out or anything.
I had no idea if he was home. Mrs. Fahey could have answered the door. I had no idea if he was home or not. I was knocking on the door to see if he was home and to ask him questions about a story I was working on.
After you filed the civil lawsuit and had those two previous things, you think you're the most unbiased reporter to be working
I'm
on that story?
tenacious.
Oh, okay.
That's the word.
That's good. No further questions, Judge.
Any further, sir?
Again, Judge, just going to clarify, I went there as a journalist. Regardless of what State Attorney Fahey's opinion is, he obviously doesn't know the definition of journalist, so he doesn't know what he's talking about. But I am a journalist. Whether you like the kind of journalism I do, whether you like the kind of opinions I give in my journalism, I went there to determine whether he was working or not, and to ask him a question. Knock on the door, which is what I did. I didn't knock on the door and stay on the porch, Judge, and try and try and intimidate him. I knocked on the door and immediately backed off of the porch into the grassy area. That's what I did. I looked for signs. I read signs. That's not what somebody who wants to commit criminal trespassing does. That's all I have. Thank you, Judge.
Any further witnesses from the defense?
No, Judge, the defense rests.
Very good. Parties prepared to proceed with closing arguments.
Yes, sir.
Yes, Judge.
Judge, in looking to the Connecticut jury instructions, Your Honor has to find that in order to find the defendant guilty, that he entered or remained in premises that are posted in a manner prescribed by law or reasonably likely to come to the attention of the intruders. The reality is, Judge, that sign that was posted, forget about the no trespassing sign. There's been a lot of talk about the no trespassing sign. Now, it is curious that the defendant would not have done further research, including looking anywhere else on the property, given how narrow that driveway was after seeing that sign. But that sign is enough. Quite frankly, Judge, I don't even think the sign is necessary, and the reason I say that is because just simply based on the animosity we've talked about that had previously existed between Sergeant Fahey and Mr. Reyes, no reasonable person in that situation would think that they were licensed or privileged to go there. When Mr. Reyes talks about an implied license, Judge, one, he started to cite, and I'm sure he'll cite again, a Florida case which has no power in the state of Connecticut. But the reality of the situation is, because every state's laws are different, the reality of the situation is the animosity alone should have told him that he had no license or privilege to go, that he would, as the jury instructions talk about, to be licensed or privileged, the defendant must either have consent from the person in possession of the premises or have some other right to be on the land. Simply calling yourself a journalist and going to the door when there's a no trespassing sign and there is animosity such as this, one does not knowingly have any right to be on that property. When one talks about implied consent, in the state's opinion, what that would suggest is you can't order something from Amazon and when the Amazon driver comes up, have him arrested. You can't take public utility services such as water or gas or electric, and when the meter reader comes up to your house, claim they're trespassing. There's an implied consent with items such as that. There clearly is no implied consent. I'm unaware of any implied consent cases in Connecticut that would suggest journalists have an absolute right, especially when property is posted, to be able to enter that property despite the signage. That sign is very clear that it was a private road. It is a driveway. It's flanked by 2 mailboxes, and Mr. Reyes chose to walk down past that sign, admitted that he saw the sign, and effectively ignored that sign. He had no license and privilege, especially, and he has knowledge of that based on the animosity and the ongoing civil lawsuit that was pending with a deposition pending. To suggest that he went there simply to ask about some other story is ludicrous. And I would ask Your Honor to find him guilty of criminal trespassing in the 3rd degree.
Judge, it's curious to me that State's Attorney Fahey now says I should have known because of animosity. You didn't hear any testimony that there was animosity. You heard testimony that I didn't approve of his actions on those days. I don't have animosity towards anyone. State's Attorney Fahey says to tell you that the implied license, and obviously he has no idea what he's talking about. The implied license for Amazon driver, a delivery driver, utility worker, and he says that I cited a Florida case. Florida v. Jardines is a Supreme Court case, Judge. It's not a Florida case. It is binding on this court. It is a Supreme Court case that acknowledges that the police and the public in general, me being an independent journalist or whatever State's Attorney Fahey thinks I am, that doesn't give me some special privilege. The general public has a privilege, just like Girl Scouts, solar panel salesmen, Jehovah's Witnesses. The general public has a license or privilege to do a knock and talk. And in some circuits, the 10th Circuit, I'm going to hand you a memorandum of law when I finish, they have said that signs don't negate. And I understand it's persuasive, not binding on this court, but they have said that signs don't negate your implied license or privilege to conduct a knock and talk. State's Attorney Fahey wants to make this case now about this animosity that is a pure fiction in his own mind. He's provided no evidence of animosity. He didn't question Mr. Fahey about any animosity. There's nothing in the record that indicates that I had any animosity towards Sergeant Fahey. But I would argue, even if I did, it wouldn't revoke my implied license or privilege to knock on the door, to conduct a knock and talk. That's what he's saying. His case is so weak. Put together the no trespassing sign, put it to the side, Judge. Put the other sign to the side. Because the animosity. Well, the statute requires a sign be posted reasonably likely to come to the attention of an intruder. I wasn't an intruder, I was a visitor. I was conducting a knock and talk. Judge, this court has narrowed this case to 2 questions. Whether the premises were posted in a manner reasonably likely to come to the attention of intruders, and whether I knew I was not licensed or privileged to be there. The state must prove both, beyond a reasonable doubt. On this record, it has proven neither. Officer Romansky is the man who testified that he found the sign, the no trespassing sign. He told this court it was in the brush, approximately 10 feet off the edge of the driveway. Now, State's Attorney Fahey would have, I'm sure he would love for me to have gone 10 feet into the bushes and rummage around in the trees to try and find something, and that didn't happen because no reasonable person would do that. They would look. You saw the video admitted to evidence. The video, the cameraman was in front of me. You see me motion him to come in front of me, specifically, Judge, so that way the camera can see. Unfortunately, yes, I've been arrested many times. I believe 13 times in the last 5 years, Judge. Not one criminal conviction. That speaks volumes to the governments that have done it, not me. Officer Romansky told me he walked down the driveway at least 2 times, up and down the driveway, before he found the sign. And he only located it after Mrs. Fahey told him where it was, where to look. Consider what that means. A trained officer standing on that property, looking for signs, walked past it twice, and he needed the homeowner's wife to point him to it. Brian Fahey testified he couldn't recall when's the last time he saw the sign posted. Mrs. Fahey said she didn't know either. She testified to that. But yet he's 90% positive. That doesn't add up. It just doesn't add up. It can't be 90% positive and you have no idea when it was last posted. He obviously was trying, his purpose in sitting in that chair was to try and defame me and discredit me to this court. Not the truth. Officer McKechnie testified. She walked the same driveway. She testified she never saw the sign. Sergeant Bedard was the leading investigative supervisor. He says he saw the sign, but never told anybody about it. Never told me, never told, nowhere to be found. Brian Fahey's testimony that he was 90% positive, but he doesn't know when's the last time he saw the sign, those 2 answers cannot live in the same testimony, Judge. He's 90% certain of the fact, he can't place the time, he's 90% sure of something, he 100% doesn't know. That is not recollection, that is a man telling the court what he needs to hear. Mr. Glover, my cameraman, walked the driveway beside me. He testified he never saw a private property no trespassing sign, Judge. I testified I never saw the sign. Not because I wasn't looking, because it wasn't able to be seen, Judge. One more thing on this element, Judge, and it is the one thing I would ask this court to weigh the most heavily. The state has not shown this court a single photograph, not one photograph, of where the no trespassing sign actually laid that day. Not one. The only photograph in this case was taken after Officer Romansky pulled that sign out of the brush and moved it to the side of the driveway, which he says he doesn't know why he did it. That's what he testified to this court. The state's evidence of posting is a photograph of a sign in a place it was not. So now the state has moved. It is no longer really arguing the trespassing sign because it cannot. It is now asking this court to convict me on the strength of yellow vehicle signs along the driveway that said private road, dead end, no turnaround. It didn't say do not enter, didn't say not welcome here. And in fact, I would submit to this court the fact that there's an existence of a no trespassing sign and this sign would indicate that it was needed to have a no trespassing sign in addition to this sign to make it clear to anyone who was going to knock on the property, knock on the door and conduct a knock and talk that they weren't welcome. I testified to what I understood those words to mean on July 11, 2025, and I understand them the same way I'm standing here today, Judge. Private road, meaning the roadway is privately owned and maintained rather than a public street. Dead end, meaning the road does not go through. No turnaround, meaning the road is not wide enough to turn a vehicle around, so do not try. Didn't bring my vehicle down there that day, Judge, because that's what I understood the sign to mean. There are traffic signs. Every word of them is addressed to a vehicle and how that road is used. Not one word of it says a visitor is unwelcome. Not one word of it says don't knock. Not one word revokes any permission to walk up to the front door. And Judge, here is how we know the Faheys themselves never believed those signs did work, because they had the addition of the no trespassing sign. The private road signs, they're on the left side of the driveway, Judge. The second sign Brian Fahey testified to was on the property of his neighbor. Those signs could have been for his neighbor. I had no idea in the moment his neighbor purchased the signs, his neighbor installed the signs. One of the two signs is on the neighbor's property. It's not clear to anybody walking up that single driveway who those signs would apply to. It's not clear. You don't have to take my word that it wasn't visible on approach, Judge, because you watched it. You saw Defendant's Exhibit A. You saw my approach to the front door. The private property no trespassing sign does not appear anywhere in that footage. The state, as I said before, did not provide any photograph of that sign whatsoever. Before I get into the knowledge element, Judge, this whole prosecution was a farce. State's Attorney Fahey charged me with criminal trespassing. I was originally charged by the Groton Police Department on the same docket for felony voyeurism.
Objection relevant.
It's what I was really charged with. This whole investigation was biased from the start, Judge. It's so clear. It was so biased. They were protecting police officers, Judge.
The fact that I reduced charges to what I thought was the appropriate charge and what we're here for is all that matters, Judge. Here, the charges have been dismissed, and so it's irrelevant.
It matters why they charged me with it in the first place, Judge. It shows the animosity by the police officers, not me. It shows the bias in their investigation.
Court's records indicate substitute information and no prior charges.
Thank you. The second question is whether I knew I was licensed or privileged to be there. I testified about my work. I'm a journalist, I investigate, and I protest allegations of government misconduct. And that is why I was on that road on July 11th. I testified about the research I conducted to do that work, about my practice, which has not changed from one residence to the next. Every time I look for signage that would tell me my permission to approach has been revoked, if I see a no trespassing sign, I don't pass it, Judge. In the last 15 years, I have not committed another crime. I have not committed any crimes. I love my family. I do not want to go to jail. I want to expose bad cops. That is the mission. That's why I went there that day, to try and expose and get information about a bad cop. And he spit in my face. The state says the fact that I was looking for one proves I might be trespassing somehow. Judge, it proves the precise opposite. A man who intends to trespass does not stop and read signage. He does not spend his walk scanning the tree line. He looks because he intends to obey, and there was nothing there to obey that day, Judge. I walked to the front door, I knocked. That is a knock and talk. That is an implied license that every single person in this country holds. It is not a novel idea, and it is not my invention. It belongs to the mail carrier, the delivery driver, the Girl Scout, the neighbor, the police officer, who may walk up and knock precisely because that is no more than any private citizen may do. When Mr. Fahey opened the door and told me to leave, I left. That the actions of a trespasser, if somebody wants to trespass on property, Judge, somebody who immediately complies. You saw the video. I I did what the license permits that I do, nothing more. And Judge, I did not learn that no trespassing sign even existed, as I testified to, on anywhere on that property until after my arrest, when I reviewed the body-worn camera footage produced to me in discovery. I could not have known July 11th when a trained officer had to be shown where to find it. A word about Mr. Fahey's testimony, both Faheys, I guess. They're both testifying today. A word about, Judge, because this court has to decide what weight it carries. He did not come into this courtroom to help it, to find facts. He came with something else in mind. He showed you what it was. Without being asked, in answers that were non-responsive to the questions put to him, he told this court more than once, I have a felony conviction. He didn't say it was 15 years ago. That conviction, 15 years old, predates my marriage, my children, my business, and has nothing whatsoever to do with whether a sign was attached to a tree in 2025. He knew, and he knew it when he said it. He volunteered it anyway more than once. That tells this court nothing about the sign and tells you everything about why that man was on the stand and why he said what he said on the stand. This is a man who spit in the face of a journalist, pulled a gun, said he was going to shoot me as I was retreating from his property. He wasn't scared. His own wife begged him not to go.
Objection. Facts on evidence.
I asked the court to disregard his testimony. He's not 90% about anything, sure about anything, about a sign, about anything. Judge, I want to talk to you about the two men who were on that lawn on July 11, 2025, and about what happened to each of them. One man walked up to a front door, knocked on it, and asked the question about $75,000 in overtime in a single year.
Objection. Facts on evidence.
Went to ask about overtime. The other man went into his house, retrieved a loaded firearm, and came back out, walked down his driveway, and after a man was already retreating towards the road,
Objection irrelevant as to criminal trespass 3 as charged.
spit in his face. That is not in dispute. Never has been. He admitted it. In the ISD. Judge, you heard in this courtroom how carefully the law was parsed that day on his behalf. Nobody performed the analysis for me. Nobody on the property that afternoon opened up 53A 109 and asked whether a sign laying in a brush 10 feet off the driveway is a posted sign. They found a reason not to charge him that day, Judge. And they found 3 charges for me. I was handcuffed, transported, processed.
Again, objection
And this court's
irrelevant
won't.
to this issue.
So are we getting back to the elements of the offense and the facts?
Yes, Judge. Understood, Judge. I've spent my career documenting injustice in this country, Judge. Standing in courthouses, holding a camera, recording what happens to people who have no one to speak for them. I've never expected to be standing inside one of those injustices myself when I started my activism 5 years ago. Answering for a sign that 3 officers couldn't even find, Judge. And another sign that doesn't indicate anything about revoking the license or privilege to be on the property. The state has failed. It utterly failed to prove anything in this case. I didn't know. They can't prove I knew. I wasn't, because I didn't. They offered no testimony, no evidence as to I should have known, other than their own made-up animosity that I don't even have, Judge. That's what the state is resting their hat on. Animosity that they can't prove. Testimony from the state's attorney. Animosity. That's what they told you in their closing. He should have known because of animosity that doesn't exist, Judge. This prosecution is another spit in my face, Judge. Difference is, this time, last time, nobody was standing between me and Brian Fahey. Today there is. That's what this court is for. That is the only reason any of us are in this room. If you want to disregard everything I said because I admitted I made a bad decision 15 years ago, Judge, that's your purview. But just remember, I testified since then. I have worked closely with police departments across our country. I have done ride-alongs, command staff meetings. District attorneys have invited me, and I've done trainings with district attorneys' offices. I bring on law enforcement officers on my channel all the time.
I'm going to object is beyond the scope of what the issues for this court.
I think that some of it is not subject to testimony, so we can get back to the argument.
Yes, sir. Like I said, Judge, if you don't take my word for it, I believe this is a country of redemption. I believe I believe myself. I paid my debt to society. But take their word for it. Take Mr. Fahey, upstanding state's attorney's word for it. Take the state's word for it. Take the law enforcement officer's word for it. Take your officer found the sign in the brush after walking past it twice, and only after being told where to look, that's when he found it. Another officer never saw it. Another sergeant said it wasn't clearly posted. The other Sergeant D'Angelo said it wasn't clearly posted. They're complaining. Can't even tell the court when's the last time they laid eyes on the sign. The state has not proven that these premises were posted in a manner reasonably likely to come to the attention of anyone walking up that driveway. It has not proven that I knew I wasn't licensed or privileged to knock on the door. Obviously, the state is not familiar with the Supreme Court case, but I will hand you, I'll educate you. Those are the elements of this offense. Both of them fail. And when the elements of a crime fail, Judge, the court of law has exactly one honest thing left to do. Find me not guilty. Thank you, Judge.
Judge, just a couple of points. I have been very clear from the very beginning with counsel that represented Mr. Reyes beforehand, and I've been very clear in this courtroom. It's that first sign. That is all that is necessary under our statute for the notice requirement to reasonably come to the attention. In fact, Mr. Reyes himself testified he saw it, he ignored it, he walked by it because he believed it to be something else. But it said, and let's be clear, he keeps referring to a road. It was a driveway, not a road. It was private property he was on, not a road, not even a private road. It was private property, a driveway that was posted private. They didn't manufacture the sign, that's how the sign came, but it was very clear from Ms. Fahey and Mr. Fahey that the whole point was to avoid trespassers in any way, shape, or form coming up their driveway, and that's why that was posted. There's been a lot of talk about the no trespassing sign. I've never, including with his counsel before, indicated that's what I was relying on as being posted. It's just curious to me that Sergeant Bedard was able to see that from the driveway walking up the first time before it got moved by Officer Romansky, and he could photograph it in place, but that he was able to see it from the driveway, but somehow Mr. Reyes and Mr. Glover weren't able to. However, that first sign alone is sufficient for notice under our statute. The animosity, the civil lawsuit, all the other that plays into the fact that he knows he was not welcome on that property, should not have been on that property. He doesn't have a right to be on that property if it's posted, and there's no, he knows there's no legitimate, he wasn't invited by Mr. Fahey to speak about anything. He went there of his own accord, and in doing so, he violated the law in the state of Connecticut. I remind the court that Mr. Fahey, that he now tells you to completely disregard, was not even called by the state, it was called by Mr. Reyes. For what purpose, I don't know, a confrontation again in court, which it resulted in ultimately further bolstering the state's claim about animosity between the two individuals dating back to that first incident. I can assure the court of one thing. I think if Mr. Fahey was not the person who walked out of that door in 2021, there would never be a claim of overtime abuse by Sergeant Fahey, because I can, and Mr. Reyes does an internet search, he too could find dozens of troopers that probably made more than Mr. Fahey. That's neither here nor there. What matters is on July 11th, did he pass a sign? Did he know the sign was there? Was it reasonably posted? It was. It was on the Fahey's property. It was on next to their driveway that they owned all the way up to the split in the road. And Kimberly Fahey actually believes the second sign to be on their property, but that's neither here nor there. That first sign is sufficient. He indicated he saw it, he walked by it, and he had no license or privilege to be there, and he knew that. I would ask Your Honor to find him guilty.
Judge?
He has no right to respond. I have the burden of proof, Judge.
No, I'm not trying.
I understand, I believe he's trying to offer memorandum of law.
Oh, that's fine. I move, Judge.
Judge, I just wanted to offer this memorandum of law.
All right. Well, we'll take the matter, or take the memorandum of law. Thank you. Absent objection, and the court's...
I assume it's not in any way, shape, or form as is required by the rules of law now in our state. There's no AI generation to all of this.
Oh, no.
Okay, fine, thank you.
All right.